Okay.
Good afternoon, everyone, and welcome to our seminar today. My name is Robert Robledo, and I'm the Executive Director of the Rental Housing Association of Southern Alameda County. Thank you to our members who are here in the audience today. For those that are non-members, welcome. We hope you consider being part of the Rental Housing Association. My Director of Membership, Sandy Moore, is also on this call. She will be following up with today's recording, as well as some additional handouts and just some other information that you might find relevant from today's webinar. We got two great speakers, and we have a lot of you on this call and more to join. So everybody is on mute. At the end of the presentation, we will leave time for questions and answers. So please put your questions in the chat and we will get to those. Sandy and myself will sort through those questions, and we might not be able to get to all of them. Apologies in advance, because again, there are a lot of you that are registered today, but we will get to them if we can. Just wanted to give you some quick Rental Housing Association news. We do have a live event, in-person event. We're very excited. September 7th, we will be having an event in Casa del Toro, and that is in downtown Hayward. And we are going to have Lily May there, along with Aisha Wahab, Sean Kumagai, and Liz Ortega, and all four of them are running for office, and this is the runoff for the November general election. Lily and Aisha are running for the State Senate District 10, and Sean and Liz are running for Assembly District 20. So we encourage you to come participate. We'll feed you lunch, and you'll get the opportunity to meet these candidates and see how they align with your viewpoints. And hopefully we can help you decide who you should support in the general election. With that being said, we're going to go ahead and turn it over to our two amazing speakers, William and Clifford, today. And before I do that, we also want to thank and do a shout out to Advent Properties for partnering with us in these webinars that we're presenting. Really appreciate the partnership. And William and Clifford, I'm going to let you guys take it away.
All right, thank you everybody. My name is William Lin. I'm with Advent Properties, and presenting with me today is Clifford Freed, who is a former boss of mine. I used to practice law with Clifford's firm, and we want to thank you for joining us. And I'll let Clifford introduce himself a little bit.
Yes, good afternoon. So I'm an attorney in the East Bay. I also have an office in San Francisco. We have a staff of attorneys that cater primarily to residential landlords, but we're also real estate attorneys, and we're available to assist you with just about any real estate problem, including small claims court issues and collecting rental debt that you might be owed. At the end of the presentation today, my contact information will be on the screen if you need to reach out to me for any advice or representation.
And just also to let everybody know, so my role today and my presentation will be coming from the point of view as a neutral person, because I actually volunteer as a temporary judge in the county in San Francisco at the Superior Court, and I presented over a number of different matters, including small claims court. So my perspective will be brought from the small claims judge's perspective. All right, thank you.
And my perspective will be from the landlord or the landlord advocate point of view. So you might get different opinions and slightly different information from William and I today.
All right, thank you. Okay, so we're going to get started. So we're going to cover a lot of ground this afternoon, and starting with how to defend a security deposit claim by a tenant, right? And then followed by a rental debt claim by landlords that are applicable, especially applicable in light of the new legislation that was passed during COVID-19. And then we're going to cover the property damage claims by landlords and late fee claims by landlords, as well as procedures in small claims court. And then if we have time, we would love to answer as many questions as you may have. Okay. So, all right. So the first issue, I think, is the most common questions that we get, or I used to get, is how to defend small claims court case concerning security deposit. So typically, these are brought by, well, they're almost always brought by tenants, unless the landlord has a claim for any sort of damages, and then the tenants could bring these claims as a cross complaint. But most commonly, we see these as standalone claims against landlords for not returning security deposit or returning too little of the security deposit. So first thing to keep in mind is that if the landlord has not followed every single requirement of the law governing small claim, of security deposit handling, then you're most likely not see any penny that you're going to be able to keep that you withheld, because it is the courts will strictly enforce those requirements on landlords. Just so everyone is on the same page, that this law was written to protect tenants, not to protect landlords. And therefore, judges are required to actually make sure that the landlord follows every step to the letter of the law. Okay, so that includes the offering of the initial inspection procedure to the tenants once you get a notice to enter, along with the 21 days to return the security deposit accounting, along with any receipts, or if you don't have receipts, estimates, followed by the sending the final invoices to the tenants. Okay, so those are all very important parts that landlords must adhere.
So William, you sit as a temporary judge in small claims court, and you hear all different kinds of claims between parties, not only landlord tenant, but what percentage of the small claims court matters that you're listening to have to do with security deposit disputes?
I would say about 25% to a third. We do get a lot of payday loan type of situations, but the other parts are security deposits, a lot of it. So security deposit is defined by law as to anything that is paid in advance to the landlord. That is, you can call it cleaning deposit, security deposit, pet deposit, but anything that is paid in advance, that is not for the first month's rent, it can be construed as a security deposit, part of the security deposit. And the security deposit limit is it would apply to the total of what you get to keep in advance. Okay, so it's the law says that you can only ask for no more than 2 months, equivalent to 2 months rent if it's a vacant unit, or up to 3 months rent if it's a furnished unit. Okay, so this is the law that actually on this particular slide is the actual law defining what is covered as security deposit. We won't go through them in detail, but you should be familiar with these rules, so you know not to overcharge, and you also know when you can actually keep. All right. So I would suggest that everybody take a look at that in more detail when you have the time, because this is actually quite explicit and doesn't cover everything, by the way. The law actually does not cover every possible deposit that you may take. All right. So these claims in small claims court are typically filed. It is to allow the parties resolve these issues quickly. So now you may have a situation, let's say you have an expensive rental and you have charged a security deposit as a 2 months rent, and that exceeded the $10,000 limit. And then you withheld the entirety of that. That presents a particular situation where the tenant may not be able to go to small claims court unless they actually agree to waive any overage, okay, that they may be entitled. So on this particular slide, I would suggest everybody take a look at it later on. You should take a look at what you're charging If you don't want to be dragged into regular civil court, you should be careful not to charge too much in security deposit. Otherwise, you may end up in regular civil court, and then you'll need most likely need an attorney like Clifford to help you defend that kind of claim, and that could be costlier than you expect. But most security deposit cases are well within small claims court jurisdiction amount of $10,000, and the penalties are a separate issue. But even if you're so I would want to make sure that everybody understand that there is a difference. Okay, so you'll have your baseline amount, which is the security deposit amount, or even the withholding amount, and then there's also the possible penalty amount. Okay, but the maximum the maximum small claims court judge can issue is $10,000, all included. All right, so let's see.
All right, so William told us that between 25%, maybe a third of the cases he hears has to do with security deposit disputes, where usually a tenant is claiming they didn't get some or all of their deposit back, and they're suing to get that back. But because of what's been happening with COVID-19, tenants not paying rent, tenants being permitted to remain in possession without paying rent, it was anticipated that there would be a lot of landlords going to small claims court to recover what's known as COVID-19 rental debt. And the laws were changed to accommodate landlords going to small claims court, so that the $10,000 limit that William just spoke about wouldn't apply. But it all started with these moratoriums that were put in place. So let me just give some of the background on that. In Alameda County, as well as Berkeley and Oakland, there are laws that prohibit landlords from evicting tenants because they haven't paid the rent. So that avenue, that remedy is not available to landlords. You cannot evict a tenant for not paying rent in Alameda County. And we don't know when that law is going to go away. It's supposed to be 60 days after the Alameda County Board of Supervisors decides that the state of emergency is over. And they met recently last month, and they could have voted to do away with the moratorium. They did not. So it's going to be with us for at least another 60 days, possibly a lot longer, unless one of the lawsuits that's been filed is successful. But that remains to be seen. So what our lawmakers did at the state level is they enacted some laws for the benefit of landlords that will allow you to go to small claims court to litigate the rental debt. Doesn't mean you can go to small claims court and evict, but you can go to small claims court and try to recover some of the back rent that is due. Now, any moratorium that's in place, whether it's Alameda County or a city, they don't require you to give up your rent money. Arguably, if you accept rental assistance from the state, you have to give up 20% of the rent you're owed. But in general, the other 80%, you're going to either get that from the state, or you can go to court if you're not participating in the rental assistance program, and you can go to small claims court and sue for that debt. So the moratoria, while it stops you from evicting, it doesn't stop you from suing on the debt that you might be owed. Okay, so let's see here, slide number 10. So beginning on November 2 of 2021, a landlord was given the option to sue in small claims court to recover the back rent. And what was unique about this provision, because landlords were always permitted to sue in small claims court for unpaid rent, a lot of the usual limitations in small claims court were lifted. Like if you have 25 tenants who haven't paid rent, you could file 25 lawsuits. If the rent is more than 10,000, you're suing for the $10,000 limit is waived. So that is something new for the small claims court. And what this new law says is that a landlord can recover COVID-19 rental debt using these new procedures, these expanded jurisdiction of in small claims court. But it's not all rent. You can't sue in small claims court for rent that was due and unpaid in, let's say, 2019. It's only to recover rental debt that was due between March 1st of 2020, basically the beginning of the pandemic, through September 30th, 2021. Now, that doesn't mean you can't sue for unpaid rent after September 2021 in small claims court. It would just be a regular small claims court action. So today we're pretty much focusing on the recovery of COVID-19 rental debt in small claims court for this particular period of time. William?
Yes. So one thing to keep in mind, small claims court, is that small claims court doesn't, it's a court of very limited jurisdiction, and that you cannot actually, the small claims court judge does not have the power to issue an order of eviction of any kind. So if you were trying to evict somebody from the premises, you cannot go through small claims court. You have to go through the regular unlawful detainer process. And so in a small claims court, just like in any other civil cases or civil cases, is that the person suing somebody for any some sort of payment for damages is the plaintiff. Okay, so for our perspective, is the landlord who is pursuing a claim against a tenant. Now, it could be the tenant suing the landlord for return of security deposit. In that case, then the roles are reversed. Okay. Now, there are different rules that apply if the landlord is a business, but is only to the extent that the business is a corporation or limited liability company or a limited partnership and that kind of business. But if you're an individual as a landlord, then most likely the procedures are more simple for individuals. Okay. Now, the person who is sued is a defendant. For our perspective, is if they're the defendant in this case, we're suing them for the rental debt or for damage to the property. But the roles are again reversed if the tenant is suing you for return of security deposit. Now, if you have multiple tenants on the lease, you need to sue all of them, because if you're using one of those form leases, most likely you would have they are all joint tenants and you're jointly and separately liable. So you do want to sue everyone. Okay, you don't want to just selectively sue one or two people. Okay, let's see. Next slide.
So to start the process of suing for COVID-19 rental debt, it starts with the filing of certain paperwork in the court, and there are forms that are made available, very special forms that were published recently just for this specific purpose. And I think it would help if I can show you Form SC 500. So I'm going to stop sharing this for just a moment and see if I could find the form. It's not that easy. I'm going to go back.
While you're doing that, Clifford, let me answer a couple of quick questions relating to the COVID-19 rental debt for you. There's one question that came out saying that can we file against people who are still living in the premises, or only small claims for people who have vacated? Again, remember the COVID-19 rental debt claims do not involve eviction. So, oh, there you go. So what you would want to do is, if you're ready to sue I would think that if they're still in possession of premises, it might be easier to serve them with the claim. Once they leave, you're going to have a very difficult time locating them and serving them properly, which will get to the part about service of process. And so, I don't recall, Clifford can probably shed some light on that, what the statute of limitations is on COVID-19 rental debt. Was the latest time you can sue?
Well, just to answer the question, the tenant doesn't have to be living there for you to sue them in small claims court. You just have to sue within the statute of limitations. So if you have a written lease agreement or a rental agreement with your tenant, you have 4 years from the date of the breach, 4 years from the date they stop paying the rent. If all you have is an oral agreement, which they still exist from time to time, you have 2 years to sue in small claims court from the date the tenant failed to make their first monthly rent payment. Okay, so I just want to briefly go over Form SC 500 because this is the one that starts the process for suing for your COVID-19 rental debt. And the Superior Court, the county you're in, most of you are going to be in Alameda County. You have to fill that in. On the rest of the first page, the clerk fills in the items on the form. You don't have to worry about that. On the second page of the form, so it's all self-explanatory. There might be more than one plaintiff if it's a married couple. Maybe they both want to appear, but it's not necessary. You just need one of the owners as a plaintiff in the case. You want to write down the names of everyone you're suing. It might be all of the tenants who are residing at the property, who are residing at the property. I don't see the reason to go after only one of the tenants, but that's how you fill in item number 2. Item number 3, again, this just to clarify, you're suing for money that's owed. You want to put in the total amount. And we're talking about the period of March 1, 2020 through September 30th, 2021. You break it down in this space here. Item number 5, William's going to talk more about this, but you have to make a demand on the tenant for the unpaid rent before you go to small claims court. I'm not sure if there are any penalties for this. But William, what if you don't make a demand before filing your claim in small claims court? Is that a defense?
It's not technically a defense. You have to have a good reason why you didn't do it. You cannot just say, it really shows whether or not you're proceeding in good faith or not. There may be situations where the judge can apply principles of equity, what's fair in light of the circumstances. And so you do not want to go to court without being able to show that you have acted in good faith, no matter what.
Just send an email to the tenant or a text saying you didn't pay your rent, pay this amount now, or else. Item number 6, why are you suing in Alameda County Courthouse? Check off box A and B because the defendant is living there. That's the best reason. And B is because that's where the contract was to be performed. So you can check off boxes A and B. One of the most important things you're going to fill out on this form is item number 9. And we're going to talk more about that in a moment. But before you can sue for this COVID-19 rental debt, you, the landlord, must make a good faith effort to help the tenant obtain rental assistance. You cannot refuse to participate in the rental assistance program, which the program is called Housing is Key. It might be some other program. So fill out item 9 and attach documentation showing what you've done to assist the tenant, what you've done to investigate whether rental assistance is available, what you've done to actually seek assistance on behalf of your tenant, and what you've done to cooperate with the tenant in obtaining rental assistance, and attach that documentation to the form. And that's pretty much what's involved with the form. You sign it, get it filed, And that would start the process. Let's get back to the PowerPoint.
While we're doing that, I believe there's a related question. So we're going to be talking, what we already talked about, naming all your tenants. Now, in these type of situation, I think there is maybe a difference between the defendants that you should be naming for COVID-19 rental debt versus the folks that you may want to sue for other types of claims, named as defendants. So your tenant, all tenants should be listed. So anyone who has a landlord-tenant relationship with you, the landlord, okay, is your tenant. Anyone who's liable to pay you rent, someone who's named in the lease or rental agreement, or someone with whom you have that verbal agreement. Unless you have specifically released them from the obligations of that tenancy, they are your tenant. They should be, they are proper defendants. Just remember that if you have an oral agreement, you need to be prepared to tell the judge how that that oral agreement was reached, approximately when, how, what the terms, material terms were, and things like that.
So after you've filed that SC 500 form, you want to serve that on your tenants, on the defendants in the action, and William will cover service of the small claims forms on the tenants in just a moment, but that is the next step in the process.
So if I may just add back to the, when it comes to rental debt collection, I think Clifford also could chime in as to who the proper defendants are. So I would not advise someone to sue tenants separately, because well, unless you're suing them all for the same amount, but the problem with that is then you have multiple cases, which you may actually make things more difficult for yourself. If you're going to seek compensation for unpaid rent, you need to be suing all tenants, those that you have not released from the obligations of the rental agreement. Because what happens is you could have a situation where if you're suing, say, A, B, and C, all for $10,000 in back rent, depends on when they are heard. That could be a problem in terms of calculating who's owing what. And the judge are going to have a hard time determining who's responsible for how much. And you really don't want to have a situation where you're suing A, B, and C each for a third of the rent. In that way, you could have created 3 separate tenancies already by doing so. So you do not want to split up your case, okay? That is something that you want to keep in mind. And if any questions as to how you should proceed, do consult an attorney, because these can be very complicated. There are unintended consequences with everything that you do in court. Anything that you do in small claims court is part of the court's file. It could be used as evidence against you in any some sort of future cases that you may have. Okay, so small claims court, like I said before, are designed to entertain basically small amounts of disputes among people, but the
on the rental.
COVID-19 rental debt is a special carved out exception to the $10,000 limit. And then the unpaid rent periods are between March 1st, 2020, and it was, sorry, the date was June 30th, 2021. So
and I said, no, Jen's bringing you home. You need to come home.
William, someone needs to mute their phone, by the way, someone who's on the line. Please all check your phone. So William, the date on this slide here, it's actually to resolve disputes between March 1st, 2020 and September 30, 2021. That's a typo.
September 30, sorry, yes. So September 30th, 2021. Now keep in mind that the statute of limitations, as Clifford described, 2 years from date of breach. If it's an oral agreement or if it's written agreements, 4 years. So you do want to keep those deadlines in mind. You can sue anytime after the breach, but within 2 or 4 years, okay? So, all right. So the rules are very much relaxed in small claims court. By the way, hearsay, those of you who are familiar with litigation, hearsay evidence is typically not allowed in civil trials or in criminal trials, but they are explicitly relaxed and allowed in small claims court. In fact, in a typical civil case, the judge is not allowed to investigate at all. It is for the parties to build and present case and defense. Whereas in small claims where the judge is actually fully empowered to investigate what happened. In fact, I could, if I wanted to, decide to take a look at the premises. And I say I can go to the rental unit if there's a defense of habitability, for example. So the small claims court is very relaxed, very different from regular civil court. Okay, and you would typically go to court in less than 3 months. Okay, depends on jurisdiction and how busy their calendars are. And so disputes are resolved very quickly. Most of the time, small claims court decisions are decided and handed down the same day. Sometimes it's handed down a week or two after, but that's all depends on the actual judge who's handling those cases. Okay, and there's a lot of information available from each county superior court as to how small claims court works in general, and in particular in their that particular superior court location. And so, for example, Alameda County Superior Court has its own set of information, but also the state's website on small claims court has a lot of helpful information. Let's see. So the first half of this particular slide actually covers the general rules governing small claims limits. The second half has to do with the special exception provided for COVID-19 rental debts. Okay, so these are for you to keep in mind. Now, these are applicable if you're suing as yourself, a natural person, but if you're suing on behalf of a corporation or a limited liability company or limited partnership, the rules are different. Okay, you're limited to how much you can sue and how frequently you can sue if you're those type of entities. All right, so just keep those in mind. Now, small claims court advisors, which are available in various counties, are available to answer those questions for you. So you sort of take advantage of those resources, or go talk to an attorney to help you with preparation of your case. Now, let's see. The next slide, please. Thank you. So the procedures we're talking about in small claims court are unique to small claims court only. In regular civil court, you must follow the rules are applicable, and you typically only understood and followed by attorneys, and they are very complicated. I've seen people representing themselves really get caught in the web of procedural requirements, and they lose a case a lot of times because they didn't know about particular procedural requirement, and that those are very harmful to your case. Now, in small claims court, there are only certain procedural requirements you must follow, and a lot of times, once those requirements are met, the judge has a lot of discretional authority to make a decision to effectuate ends of justice. Okay, so those are things to keep in mind. But it doesn't hurt to consult an attorney to understand what you must do and how you can best present your case, and even in small claims court. Okay, because as somebody who's been in small claims court quite a lot, I really appreciate it when a litigant is properly prepared for trial, and makes my job a lot easier. Because just so you know, a lot of times there are multiple cases at the same set for the same time, and you are really limited. Let's say if typically, at least in San Francisco, we have each session is only an hour and a half. That's if you have 4 cases, that means each case can only get maybe 10, 15 minutes. And so each side gets even less time. So it is something to keep in mind that you may not get the full hour and a half to present your case. You may, but don't bank on it. Okay. So again, you have so one of the requirements in small claims court that you must follow is use of the right form. It's a form intensive process. You got to use the correct form. Typically, it's a form SC 100. That's for any claim, except for COVID-19 rental debt claim, which is the form SC 500. And any other forms that you may get your hands on probably are wrong. So again, consult an attorney or small claims court advisor to figure out how you can use it. If you need to submit any sort of supporting declaration, which we'll cover in a second, there are forms that the courts will provide to you for that purpose as well. But they're not, usually you don't need it unless you want to use it. And even if you don't use those forms, those are optional use. If you don't use those forms, most small claim judges won't hold you to those. All right, so let's see.
The actual form that you're going to be using to start the process is the plaintiff's claim form. For COVID-19 rental debt, it's going to be that 500 form. If you're suing for rent money due after September of 2021, it's the usual SC 100 form. So those are the two different forms there.
Sorry, if I can say something real quick. So by the way, you don't have to sue the tenant in one case for all back rent, for example, even for COVID-19 rental debt, or preferably you should, so that you don't have to keep on going back to court. If you, you could actually sue them if, let's say, they're paying on a monthly basis. You can literally file one case for, say, 3 months, for example, if you wanted to, and so on and so forth. But keep in mind the frequency and limits that are applicable to general small claims court cases. All right. So in small claims court, one of the unique things about small claims court is that it's designed so that everyday people can proceed to court without any sort of professional assistance. And for that same reason, lawyers are not allowed except for small claims appeals. So basically, you are required to know under what law you can seek whatever compensation you're seeking. And you have to also know the court procedures. So you have to study up on the requirements, or consult an attorney, or consult a small claims advisor if the court has one. And so in small claims court, everybody's treated the same way. The only time, the one time attorneys are allowed is if the attorney is a party to a small claims case as either plaintiff or defendant. That's the only time an attorney may appear, is for themselves. Okay, and you are required. Everybody's required to know the law, the rules, and all that.
So William, do you think it's a good idea that people who are going to go to small claims court sit in and watch a small claims court proceeding, and how would they do that? Well,
so at least in San Francisco, small claims court is in person, so anyone can just show up to the court to attend. I haven't looked at the what Alameda County has been doing in this on small claims court, assuming that it's in person. All these proceedings are open to the public. Now, I know in San Francisco and some of the jurisdictions, they also allow remote appearances for some litigants. And so while you cannot dial in to watch, you can still go in person to observe. And so that is how that will work.
It's a pretty good idea to get a sense of what happens in small claims court before it's showtime for you to go to small claims court. The other thing is you are also allowed to consult with a lawyer before you go to small claims court. If you're suing for a lot of back rent in excess of $10,000, it might be worth your while to sit down with a landlord attorney and go over your claim, maybe even before you file your SC 500 form, and definitely before you go into court to present your case. So while you can't have a lawyer in court with you, to act as your advocate, you can get legal advice from an attorney about your small claims court matter. Okay, William, we're going to go through a bunch of procedure now. As a judge, you get to see a lot in small claims court, and there's a lot of procedure there. But if you could just go through these next few slides pretty quickly and let the audience know how these procedures work.
All right, so we're going to skip over to, if that's all right, slide number 22. By the way, the slides are being made available for download if I'm correct. Is that correct, Robert? You'd be sending out the slides to the members?
Yes, we will be sending out, I'm sorry, we will be sending out the slides and other handouts along with the recording.
Great, thank you. So just in case you didn't catch any of this before, the slides will be made available to you. And just full disclosure, a lot of information here are borrowed from the Judicial Council's website. Judicial Council of California has very exhaustive database with all this information. This is a simplified version of what they have on their website. All right. So the first thing, of course, you want to do is figure out who the defendants are, what you should, how you should name them. So next slide, please. So whenever if you have a question about this, this is a very general one, not just suing your tenants necessarily, but if you are suing anybody in small claims court, you should name as many people or businesses as you believe are responsible for your loss in any way. The small claims court judge will make the determination as to whether or not some people are properly liable or not. If you limit yourself as to the number of the defendants, then the court really can't help you other than telling you you have sued the wrong person, for example, if you sued the wrong person or persons. So I've actually had to do that a number of times in small claims court when the wrong party was sued, named in the lawsuit. And then the next thing about it is that you have to know the exact name or names of every defendant that you are suing. Okay, so and here's some additional information. Examples as how you should do it for your tenants. Really, you need to name them as they are named in the leases or rental agreements you have. Okay, if they're known to you by any other names, you should use sue them also known as. These are the names. The more names you have for a person, if there are more than one name, the better, because then you'll have a wider net to cast when it comes to time for collection. All right, and next page is about corporation limited partnership LLCs. It's a lot more complicated now. So the state of California, the Secretary of State's office has a online service where you can search businesses that are registered to do business in California and give you the information about them. For example, the website will provide you with information as to whether or not the business is actually in good standing, for example. Just so you know, if a business is not in good standing or not in active status, they cannot defend themselves in court at all. Okay, they cannot start a case, they cannot sue, and they cannot defend themselves. Which means if you have that piece of information readily available when you go to court and you're suing an entity defendant and they are inactive for any reason, sometimes you'll see FTB forfeited. That means they didn't pay their franchise tax for taxes. They got put in forfeit status. They cannot do anything unless they have revived themselves by paying the necessary taxes. So in fact, what that means is they will proceed by default against them. You still have to prove your case, but it will be easier. So which court do you file it in? Well, if it's over rental debt, it will be where the tenancy is located, where the property is. And so these are a bit more details there for you to just take a look at. Okay. Forms, like I said before, the SC 100 or the SC 500 forms are used. Now you may have two different cases, one for damage to the property for tenants who have vacated, and then you also have COVID-19 rental debt. You will use both forms, but there'll be two different cases. Okay, you cannot mix the two claims. And if you have any questions about completing the form, you need to contact your attorney or small claims advisor or do your research online in order to make sure that everything's done correctly. Then once everything's filled out correctly, you'll need to pay a fee to file these claims with the appropriate court. And if I remember correctly, still, Hayward Hall of Justice is where small claims matters are heard in Alameda County. They would prefer that you file it over there, although I do recall Alameda County allowing filing of different cases at various court locations. But it may be easiest if you go down to Hayward Hall of Justice to file that, okay? And then after that, once the case is filed, you have to serve a copy of that on the defendant or defendants. So you need to make sure you have enough copies for filing. Once it's you need to make sure that you have enough copies for filing. You need to retain a copy and want another copy so that you can make a copy of that copy to serve. And service or process is its own beast, depending on who you're serving, whom you're serving, and where they are. And personal service is the preferred method of service. That means physically handing the papers to the defendants. A party cannot personally serve another party. And you have to use a third party who's at least 18 years old. Now, there are professionals out there that can help you with the service. For example, there are professional process servers. For a fee, they will serve. A lot of times they will even locate the defendant. If you do not know their whereabouts, you can pay them to find the tenant, the former tenant rather, and then serve them as well. So, and then county sheriff's office has a service, or marshal's office if there's a marshal in the county. I'm not familiar with any California county that has marshals these days, but Alameda County Sheriff's Office could serve people as well. They do charge you a fee, but you have to follow the right procedure. And there's another disfavored process, which is having the court clerk serve for you. But that is a certified mail with return receipt process. Now, if service is incomplete or you do not have the proper proof of service on file, your case will not be heard the date it was originally set. The court clerks will either extend it to a future date for compliance of proof of service requirement, or the judge could dismiss your case. Okay, so, but most likely they will continue for you.
William, there is a handout that will be made available on giving some specific details on serving defendants. So if anybody has any questions, they should refer to that handout. So I'm going to talk a little bit about actually going through the trial. If serving the lawsuit on your tenant doesn't get you paid, sometimes it will because the tenant doesn't want to go to court, then you have to go to trial. And many times tenants don't appear at trial. Serve everything, the date comes, they don't show up. So what does that mean? You still have to present your case. So if you see Judge Williams sitting on the bench here, you have to show him that you are entitled to this money, that you have a contract, a rental agreement, that you're owed the money, and you have to go through your basic case in chief. When you show up in court, the clerk will give some basic instructions on how to present your case. Presenting evidence at trial, there are two kinds of evidence. One is going to be documents or exhibits that you bring to the court. Some of these documents will have already been attached to your SC 500 or your SC 100 claim form, but bring all of your documentation with you, including your rental agreements and leases, any rent ledger showing how the rent is due and unpaid, and your demand that you made on the tenant for payment, because you checked off the box on the claim form that you made a demand before filing. So bring that demand with you. If there were partial rent payments, either by the tenant, by rental assistance, housing is key, bring all that proof with you as well. And if you don't have the documentation to prove your case, you can testify to certain items. Oral testimony is just as good as written evidence, although if there is a written document to prove a point, you want to bring that with you because that tends to be stronger than just your testimony. You want to bring multiple copies of your evidence to court because you need one for the defendant. At the beginning, the clerk of the court is going to ask you to share your evidence with the tenant. So you want to bring a copy of your evidence. You want to bring one for the judge, one for yourself, and an extra copy, I guess, in case the dog eats one of the copies. Doesn't hurt to have an extra copy. And you exchange the exhibits. Now, in the past, when I've assisted landlords who are going to small claims court, I also prepare a trial brief that summarizes the evidence and the law. And I would like to ask William, what do you think of briefs that are presented to you? Not the evidence part, but just the argument in writing. Is that helpful, or do you just throw it in the waste can?
It's helpful if there's time for the judge to even consider it. What happens is people are generally very disorganized and they are all over the places. If it's a factually confusing situation, I think briefs are helpful. It guides the judge through what actually happened, and then we can follow along and try to see if we hear the evidence we need for that particular claim. I've seen situations where people are just they're all over the places, literally, and I have to work really hard to focus them and ask very specific questions as to when, what, where, how, who, and all that, and otherwise I have zero idea what's going on. I mean, the thing is, the judges do read the complaints typically ahead of time. So your complaint, the more information that you put in the complaint, the better. And what happens is, I know at least in San Francisco, when there are opportunities to read, every judge will try to study up on it so that they don't waste their time on the bench, because they don't know how busy things are going to be.
So the complaint really is a summary of the landlord's case, but it's a factual summary. What's missing really is the law. And some judges sitting on small claims court, they may not know the law. They may not know about the moratorium, about all these laws that pertain to the collection of COVID-19 rental debt. I think it's a good idea to present some of that law to the small claims court judge, but you're going to need help with that. If you're not smart enough to marshal all of that law together, go get some help from a landlord attorney. So what arguments can you anticipate that the tenant is going to throw your way? How are they going to defend? What might the judge ask you about your claim for COVID-19 rental debt? Probably the best argument against your case, against your right to recover, is that you failed to make a good faith effort to investigate whether there was rental assistance for the tenant. As bizarre as it sounds, the burden is put on the landlord to investigate and seek assistance for the tenant. So you should come into court with proof. Expect this argument. Expect the tenant to say that you didn't cooperate, you didn't fill out an application. You want to show that it's the opposite, that you bent over backwards to get rental assistance for the tenant, and bring all of your efforts that you made in writing, present that to the court. So that's going to be the biggest argument you're going to have to face. So anticipate that. Another argument is tenants can say, I'm waiting. I applied, the landlord did cooperate, but there's a pending application. And this argument is a little controversial, because we all know that housing is key and all these other programs, they're running out of money. They have backlogs of like 28,000 applications, and there is no money there. So does that mean that the landlord can't go to small claims court because there's a pending application? William, let me ask you, you're sitting on the bench and the landlord and the tenant are in agreement. Yeah, okay, the rent is owed, but there's a pending application. Is that a defense?
So the court needs to know whether where they are with that. So there is under the Housing is Key program, there is an email address. You could email to get a status. They'll give you something to talk about where they are with that information. Now, if well, it depends on what it says. So they could say that this is the process still pending due to XYZ. That depends on what XYZ is. If it says it's tenant hasn't responded or hasn't followed up, there's some issue with the tenant, then of course then that goes against the tenant. And if they're saying that, well, waiting for the landlord to provide XYZ, well, then it's weighed against the landlord. So that is how that would go.
So, and then if we look at this next slide here, there are the typical arguments that tenants will make is that you made a demand for too much rent, you're not owed all that rent, that there was an improper rent increase, that the premises is in breach of the warranty of habitability. Those are typical arguments that you hear in a lot of these cases. Okay, William, you want to talk about where our audience could go to get some more help about small claims court?
So yes, so the best place to go is courts.ca.gov. That's the California Judicial Council's website. It has just a ton of information as to how you can help yourself in small claims court, how to proceed, and things like that. But if you're not inclined or you don't have the time to learn all these intricate details about small claims court proceedings, the best thing to do is contact someone like Clifford's office for assistance in preparing your case.
So William, the decision comes in and the judge made the wrong decision. You're the landlord, you disagree, you can't believe it. 2 years worth of rent, you haven't seen it. What happens now?
So there are ways that you can win and also lose at the same time. For example, if you sue for $10,000, but the judgment's for you for $100, guess what? You're out of luck. You cannot appeal that decision. And whereas the tenant can, if the tenant chooses to, but if it's $100, most tenants won't probably won't want to challenge that. So you get this one shot. You got to do it. You better make it your best shot. Don't go in unprepared. Get as much help as you can ahead of time, because only the lose. So if the plaintiff loses, you cannot appeal. Okay. Well, sorry. If you win your claim, even no matter how small it is, if it's in your favor, if it's any award in your favor, you cannot appeal that. So that is really the I think the catch in all of this. The tenant can if it's against them. Okay. So if the tenant has a counter claim or cross claim, the rule is the same.
So William, let's take your example. The landlord is victorious. They were awarded their $100. What's the next step?
Well, within 30 days, typically the court will send you the final judgment with the next steps now. And the tenants may or may not appeal, but in fact, if you're seeking $10,000, you only get $100. I don't think the tenant's likely to appeal that, because that means you lose the right to pursue the $9,900 that you think you're owed. So you're really out of luck at that point. And then if you want to collect, you could, and then you would go through the normal process. And most likely, I think I've seen is that most defendants in those cases, when they have a small amount of judgment, they most likely would just pay, and they'll be done with it, because they don't have to go through any further tangling with the landlord or the plaintiff in that case.
Okay, well,
Right.
Thank you, William. In the short amount of time that we had, I think we covered a lot of material, but it was the basics. And if anything else, if nothing else, it'll get landlords thinking about not waiting for the moratorium to go away, but going to small claims court to recover some of this back rent that they're owed. So Robert, I know you've been looking at the questions coming in. Go ahead and fire away.
Yeah, we have, I'm sorry, and we probably are not going to get to all of these. There was like 22 questions that came in, and I wrote them all down on a Word document. This is probably a quick answer. Does the $10,000 limit apply to rental debt that accrues after September 2021?
Yes.
Okay, perfect. Lawrence Kennedy, Clifford, I already sent that to you, so you can deal with him separately offline. What if tenants are not on the lease? Do I still need to sue them?
If a tenant is not on the lease, but you have an agreement with them, whether it's an oral agreement or an implied agreement, you should name them. They're living at your property and not paying. Well, they're your tenant and they owe you something for living at the property, so you should name them.
Okay.
And there's another related question I saw earlier is that about those who have left, tenants that were on the agreement but left, no longer living in the place. Now, unless you have explicitly released them from the rental obligations, you should still name them. They're still liable, jointly and separately. So it doesn't hurt to name them all. And even they have left, legally speaking, they're still liable to you.
Okay.
So if the person doesn't have an address to be able to, can they still sue that person?
You will need to find their address either by yourself, by employing one of these search websites, or get a process server. Most process servers have access to find addresses. People.
Okay.
The more information you have about the defendant, the better, the easier for them to find that person.
Okay, I think this kind of goes along with the other question asked earlier. What can a landlord do to recover funds well over the 10K limit for tenants who haven't paid rent through most of 2022?
So I think for most of 2022, there are different choices. First of all, there's some eviction options available unless you're in Alameda County. If you're outside of Alameda County, you do have some eviction options, but you would sue the tenant in small claims court if it's more than $10,000. Don't go to small claims court. You could file a regular lawsuit in regular court, either on your own or with the assistance of a lawyer. And I'm available to assist you and help you make those decisions, whether you should be going to small claims court, whether you should be going to regular court on your own, or hiring a lawyer to go to court for you, depending on how much debt is due. So I'm showing contact information on the screen here. This is how you would reach me if you need any services from us. And William, besides being a judge in small claims court, he does work with Advent Properties, and he's also very knowledgeable about collecting debt, managing properties, and his contact information is available on the screen as well. Robert, next question.
Okay, can a housing provider report past due rents to the 3 major credit bureaus? Or is there a law which states that you can't?
Good question. William?
Yes and no. There's a protected period, and there's so you can, when it's not, you're not reporting during the period that's protected by state law. So for most of I would say most of 2022, yes, you can, but it's a protected period during the COVID-19 rental debt coverage. I believe that the law says you cannot.
Do you think that these credit reporting agencies, tenant screening services, that they know about the law and would advise the landlord, well, no, we can't report that?
They do. So our company uses a property management software platform, and we actually report unpaid rents to the Rent Bureau, a service of Experian, and they would literally block off those months automatically. They already do, because they can be liable too, so they don't do that.
Robert, next question.
Okay, I'm just gonna do a shout out to Rebecca. Rebecca, I can answer your question. I'll offer that. I will reach out to you after the presentation because I'm pretty versed in the ERAP program, so I will get back to you on that one. Raj asked how much of what is being said here by presenters apply also to Contra Costa County rental properties.
I would say that all of it applies. The only difference is in Contra Costa County, you might have an eviction option. And I think a lot of you, if you had your preference, you'd want to get your tenant out if they're not paying rent. But otherwise, you can go to small claims court and everything we've been saying here is the same, except when you fill out Form SC 100 and SC 500, you're writing down Contra Costa County, not Alameda County.
The next question, I think I know the answer to this one too, but for unpaid rent due on or after February 1st, 2022, may a landlord go to small claims court to file a claim? If so, how are the rules different or the same?
So the answer is yes. And William, since you covered this during the presentation, what's the difference between a COVID-19 debt collection and other kind of rent collection?
Well, first of all, the form, you got to use the right form. You can't use SC 500. You have to use SC 100. Okay. And most of the defenses are similar. And there are, just so everyone knows, I think one thing we didn't say is that there are still charitable organizations out there providing one-time rental assistance to tenants. So I would still try my best to work with the tenants even after the coverage period to show that I have acted the utmost good faith before going to court. And because at some point, if your small claims judge is one that's sympathetic to the plight of the tenants, then that person is going to try every single way that he or she can to not give you what you are seeking. So so I would definitely try to make yourself look as good as can be before a third party by trying to work with the tenants first. And that also goes into the effort about making the demand, following up as to, hey, have you gotten the money is due? What can we help you to get more assistance? That kind of things. That will go a long way to show that you're entitled to the money in small claims court. There's one question I'd like to address that was asked earlier on about depreciation. That's about a surety deposit. So there are a couple of things, just so everybody knows, the Department of Real Estate publishes the California Tenants Guide that has just recently this year been updated. So that one is published to everybody in the state of California, and it primarily is for the tenants to use in aid of their arguments with landlords. Really, in that particular publication, they use a very short depreciation schedule when it comes to calculating, for example, painting charges, how much is appropriate to charge to deduct from the tenant's deposit. They use a 2-year useful life. In our own practice, we use 5-year useful life. And there is yet another schedule, which is the IRS schedule. IRS publication 827 actually has its own schedule on what rental property owners may use properly for IRS purposes. So I would say anything between the 2-year and the IRS maximum, it should be fine. It just want you keep it consistent and you document that clearly. That you have to make sure that you do that. If you have some sort of established rules for yourself, that will be very helpful to you in small claims court in defending the amount withheld.
I think this question kind of goes along with what you were just talking about, William. What if the tenant has applied for the ERAP program, but a decision has not been made whether to grant it? Does the small claims court require a decision before to grant a landlord release?
No. It's whether or not the judge has actually a lot of leeway as to what can be granted. The judge can even, if a judge is so inclined, thinking that if both parties have shown the utmost good faith in trying to get the rental debt repaid, and simply is a function of the rental assistance program not coming through. Like I said, you could actually ask the rental assistance program as to the reasons why they haven't made a decision. Okay, and they will tell you whether it's they're waiting for tenants to do something or landlord to do something. They will tell you. So again, that will be counted against the party whose action that is causing this holdup. Now, if that information is not available, a judge can actually dismiss the claim without prejudice, meaning that you can bring it again later on. And so you can always ask for that if you don't think that the case is going in your direction, in your favor. Then you can voluntarily dismiss the case without prejudice, so you can bring it again later on.
I think it would be helpful if the landlord is arguing to the small claims court judge, I call every day for rental assistance and they never pick up the phone, or they keep telling me, we don't know what's going on. If the landlord could show that they've been working to get that rental assistance money, but it's not forthcoming, all they're hearing is silence, that can only help, especially if the tenant says, yeah, I haven't called since I submitted the application. That shows the tenant isn't doing anything. But if the landlord says, I'm told they have no money, I keep calling, they put me on hold, this has been going on for a year, that's going to work to the landlord's benefit.
And so it's personal anecdote. I have called the number on behalf of a client before, and several times. I've always gotten somebody. And each time I would document my conversation in a note. And then I summarize the note by sending the program an email asking for further information. And surprisingly enough, the email that I send usually gets zero response. I get more response by calling. And so if you can document your efforts by sending emails and there's no, to which you receive no response, and you may have just proven your case. And because you're not, it is not required that adjudication has been made in terms of that particular application. Now, I have seen the case before, at least in San Francisco, where between the time of filing and the time of hearing, the landlord did get something. So the claim was reduced for that payment amount. So that it is happening. So you just never know. But constantly checking. If you can come to court saying, I literally just called yesterday, and this is the information I'm given. And that will go a long way to support your claim, regardless of what kind of claim it is.
Okay, we are over right now, Clifford and William. So, I mean, I don't know if you both have time still or not.
I think I have time for a couple of more questions.
Okay.
I have a little time too.
Okay, great. All right, good. Thank you. What about the 12-month waiting period? When does that clock start ticking? And I think that's in relation to filing for the ERAP program, and then you have to wait that 12 months before you can file in small claims court.
Let me see.
This is not ringing a bell. So
Okay, it might be an Alameda County ERAP part. I know that something was tied to the ERAP program on that. Correct, Sandy? If I'm wrong.
No, that's correct. It's
Okay. All right. Okay, so we can.
Sounds like it's a 12-month wait period to get funded by ERAP. That doesn't necessarily, I don't know if it has anything to do with small claims court. It might be a local rule that's imposed.
Okay. What if a tenant stopped paying rent in October 2021? Are landlords still able to take tenants to small claims since COVID eviction moratorium is still in place?
Yes, the moratorium is against evictions. It's not a moratorium against collecting rent that's due.
Okay.
so basically, I'm sorry, really quick, whatever time frame we're looking at, even way back in February of 2020, if rent wasn't paid or whatever, they can still sue for that amount.
Yes.
Okay.
There are a couple other, I think, very sort of esoteric questions about small claims court procedure. So one of the question is, can the defendant make a motion to link to an existing civil case,
Yeah.
either small claims case or an appeal, yes, there are motions available, but it's unlikely that a small claims court judge will, it depends on the facts, obviously. If there's a good reason to have the cases consolidated, then the small claims court judge is empowered to do so, to have a case transferred. I've done that once in the last 4 years. But an appeal is typically not linked to anything else. That's an appeal of the underlying case. So that is a no, but you could combine small claims court cases to be heard at the same time. That's very common. But if it's a regular civil case with a small claims court case, if the issues are similar or the facts are we'll call the events giving rise to the claims are similar, yes, you could, the small claims court judge can choose to transfer or consolidate the case. There's another question about, can the tenants be sued for legal fees associated with their case? Well, depends on your contract. If your contract doesn't say that a prevailing party of some case is arising out of the lease is entitled to legal fees, theoretically you can, unless, I mean, you wouldn't necessarily do it this way, because typically if you win the case, you will ask for that particular judge to get you your fees as a motion, but you wouldn't necessarily sue separately.
But William, we're not talking about legal fees in small claims court, because you can't have a lawyer in small claims court. So what legal fees are you suing for?
I'm actually now I'm thinking about this. I think they're talking about maybe consulting a lawyer and paying that lawyer for the consultation and then suing for that expense. I
think that's legitimate. If someone comes to see me before they file in small claims court about what their options are, explaining to them the law, they've incurred those legal fees.
Mhm.
But you'd have to look at the language of your rental agreement and see exactly what it says.
Okay, is it better to wait for the tenancy to end so that the landlord knows how much to claim before filing a small claims court? Otherwise, the landlord has to file multiple times. Is there a maximum number of times a landlord can file for the same tenant?
So I think that every month is a separate rental obligation, and a landlord can file a small claims court action every month as the rent becomes due. It's an awful lot of work to do that, but I think the person who asked this question isn't asking if they should be suing every month for rent that's owed. But I believe that suing sooner rather than later in small claims court is better, because you could be sitting there for many more months or years without collecting rent. And maybe your small claims court action is just the pressure your tenant needs to start paying, or better yet, to get out of your property.
So I would, sorry, if I would refer that person back to our slide number, page 16. So that may, depending on the dollar amount of each month's rent. So you could, so if you're not seeking more than $2,500, you can sue as many times as you want. Case. What I'm basically, this is what it is, that the state of California and the courts want their filing fees. That's what this is. And so keep in mind, those are the limitations.
What are the filing fees? We haven't talked about
It
that.
depends on the dollar amount. I think it starts at, let me look it up. Sorry, I haven't looked at it in a while.
I recall it being between $30 and maybe $90 for filing fees, depending on the amount in dispute.
Yeah, it's set by statute, actually. It's uniform throughout the state, no matter where you are. Let me take a quick look here.
While William's looking for that, Robert, do you have maybe one last question?
Well, I have one last one, if it's okay.
Please.
Clifford, what if in the small claims court, the defendant does not show up? Did we cover that?
We
If the
did.
defendant does not show up, two things could happen. Well, one thing that will happen is there will be what's called a prove-up hearing, where the landlord presents their case in chief. You go through the claim in Form SC 500, present that to the court, a decision is made, and most likely the landlords are going to prevail because there was no opposition. But there is a procedure for the defendant to come, I believe, to come back to court and say, oops, I missed the bus. So William, I know you're looking up what the filing fees are. What happens when a party doesn't show up in small claims court? They miss their trial date, first starting with the landlord and then with the tenant.
So if a party, if the defendant, so if the plaintiff doesn't show up, then the case is dismissed. The tenant wins. If the plaintiff shows up, defendant is not there, and there's a valid proof of service, then we will proceed with the plaintiff's claim. They still have to prove to the judge's satisfaction that they're entitled to the judgment they're seeking.
Can the tenant come back and say, I missed the bus, let me have a new trial?
They a lot of times they do. They will either file a motion to vacate or try to appeal, but generally speaking, those are a waste of their time. Because if you miss your, unless you're in the hospital, some really, really, really good reason why you missed it, then there's no, yeah. And one thing the courts don't like is wasting its own time by having multiple hearings on the same issue.
Okay, so speaking about missing trial, I'm gonna have to get going any moment now.
Okay,
I don't want to make the judge angry by missing my next court appointment.
Well, I want to
So
thank you
the
both.
filing fees are between $30 and $75. So depending on the dollar amount, and then it goes up if you file more than 12 claims a year. So if you file one a month, the filing fee more than 12, it'll be $100.
okay.
Great. Well, again, thank you, Clifford and William. Awesome information and a great presentation. I know there was a lot of questions. Really appreciate your time, and thank you all for being here today. Enjoy the rest of your afternoon.
Thank you,
And
Robert.
thank you.
Thank you, Sandy.
Thank
Thank
you.
you.
Have a
Thank
great
you,
day.
audience. Bye-bye
Have a
now.
good day. Bye.